Hello. Hi, Harish.
Hey Michelle, how are you?
Good, how are you?
Good. Can you hear me okay?
I can hear you perfectly.
Awesome.
Sorry, I've had to reinstall Zoom like in the last minute.
Oh,
Of course. I'm gonna make you a co-host here.
so,
You'll see we do have our newsletter coming out next week, and we are changing some of our processes for the new year. So you'll see some things that are changing. Some of the processes are changing for the rebels, so you'll see some new things coming for the new year, which is exciting. But before we get into any of that, I'm going to turn it over to our presenters today. So we have Vidya and Harish talking about the changes in immigration. So I'm going to turn it over, and if you need anything from me, I'll be here. I can
sounds
watch the
good.
chat for you both too if you need.
Yeah, that'll be great. Thank you, Michelle. I'll kick off for a second and I'll pass it to Vidya. Harish Parwani, founder and CEO of CrossingLegal.ai. We're building a comprehensive immigration case management platform that really combines artificial intelligence with workflows that uh, traditionally have not been associated with the industry, but are really the need of the hour. So what we did is we brought in Vidya Parwani, who is she's an established attorney. Vidya has been practicing immigration law for 15 plus years, and to really talk about recent changes in U.S. immigration, etc. Our goal is to keep this very conversational. So if you guys have questions, feel free to jump in, unmute yourself, or use the chat. Uh, Really, the goal is to provide this group with as much information as we can, especially when there's always a new immigration news like every 2 days in the current environment with the current administration. So without further ado, going to hand it over to you, Vidya, to go talk about the fun and complex world of U.S. immigration.
Yes. Hi, everyone. I'm Vidya Parwani. I'm an immigration attorney and practicing over 15 years now. Did you want to put the agenda first or? Yes. So today we will cover, I mean, there's a lot of topics to cover, but I think most relevant for HR professionals is the current travel ban expansion, the H-1B 100,000 fee addition, the modernization of H-1B rules, the enhanced vetting that's going on, um, rules around the EAD, the changes, and when you're processing green cards, the timing around PERM and prevailing wage requests, and some action items I would just recommend for HR professionals. And of course, we can do Q&A at the end, but please feel free, like Harish said, to ask me questions throughout while we are on the topic, so that, in case, it might also be something I forgot to mention, and it would be good to have that. So we can start discussing the travel ban expansion. So when I prepared this slide at the time, I was focusing on the June travel ban countries of 19, and we were expecting an announcement when I prepared the slide, and that announcement was literally made yesterday. So now not 30, but 20 countries were added. So in total, now there are 39 countries under the travel ban, out of which let me see, 18 are what you call a full ban, so a lot of restrictions for them, and another 21 have partial restrictions. But whether it's a full restriction or a partial restriction, like in partial, they could get a visa and things like that. It's fair to assume that anyone from any of those countries is under a lot of scrutiny. And this does not only mean folks who are outside the United States and planning to come here on a visa to work or live, but it's also the folks who are within the United States. So it will be current employees who are from those countries, and they are looking at country of birth. So usually it's country of birth, but with this travel ban, I'm also skeptical that they might be looking at citizenship as well. but it's usually on their passports. So they could have a passport from the UK, but they could be born in one of these countries as well. So it's very important to look at both citizenship and country of birth in identifying the folks who are subject to the travel ban. So because you'll see that even when you are already having them, whether it's on an EAD card or an OPT or on a work visa, any further processing for them or any renewals of those work visas or work authorizations are now going to be affected due to the travel ban. And in addition, they will be from abroad, so they will be making trips outside the United States, so their travel is going to get very much restricted. So within the organization, it's very much recommended that you have some type of audit system, that you identify who are these folks who are subject to the travel ban. Are there any questions regarding the travel ban? No, we did see a similar travel ban also during the previous Trump administration. And it's also very important to see who are your folks currently outside the country, because we literally had people going to the consulate at that time who were stuck and were unable to return to the United States. So it's very important to keep a close eye to this. Now, coming to work visas, so we will touch upon the most common work visa, which is the H-1B, which has also been a lot in the news and a lot of changes. The biggest change has been the one that took place on September 21st of this year, that when you are sponsoring anybody who's outside the United States, you are subject as an employer to pay the $100,000 fee. It's an online fee that you'll be paying through pay.gov. The good news is, compared to when they announced the 100,000 fee, they clarified much later that this does not apply to folks who are already here on H1s, who are undergoing renewals and extensions. Technically, also, if those folks travel outside the country and have to go for a new visa H1 stamp, they should not be subject to this fee. Petitions filed before September 21st are also exempt from this fee. So even if somebody has never got a H-1B visa in their passport before, but their petition was filed like most likely in the previous lottery, and now they're going on vacation and they need to get stamping, they are also exempt from that fee. This fee will really apply to folks who are now as we go for the new lottery next year in March, when a lot of times you want to hire individuals from outside the United States. This fee will apply to them, so that's a big price tag, and you have to look into your budget that can you afford to employ that employee. And this is a fee to be paid by the employer, because H-1B fees are paid by the employer. It's an employer's petition. The employee does not sign anywhere, so these fees are the burden of the employer. Even though it should not affect H-1B travel, a lot of folks on H-1B are very scared to travel. But I do not think that it's as much as due to this fee, because we have been hearing that people are getting their stamping done without being subject to this fee if they're in one of those exemption categories. But it's a lot to do with the other rules that are changing, which I will be touching upon next. But yes, that's one part of the H-1B where you can see the cost of H-1B going high. Talking about the coming lottery, which already folks are now starting to prepare for in March, USCIS is looking into having a system where they want to prefer folks who are in a higher wage level. So there are 4 wage levels. We have level 1 through level 4 wage. Generally, how it works in companies is, if you have somebody who's an entry level position, they fall under level 1 or level 2 wage. When you're usually doing a transfer and a person has some work experience, then it's a level 3 or 4 wage. So what USCIS is saying is that they will give more chances for those folks who are in level 4 wage, then a bit less, but still more than others for level 3, level 2, level 1. So in other words, what it will mean is, for entry level positions And if you're giving them if you're planning to pay them around the level 1 wage, the chances of them getting through the lottery will be much less. Previously, it was only a distinction between masters and bachelors because they had additional quota numbers for masters. But now the wage is also going to play a role in the H1 lottery. Let me know if you guys have any questions so that I can move forward. So coming to the other changes in H1, the new modernization rules. Let me just change the slide. Yes. A lot
So
of
this
changes.
doesn't,
Yes.
this doesn't affect any of like the EB one or any of the other visas, does it?
The 100,000 and
Right.
the wage.
Yeah.
No, this is all but
Only
to
H-1B.
H1s.
Okay.
Yeah, and that's a good question, because what we are seeing now is that companies are saying, hey, let's just do an O1, but the person has to be qualified also for an O, which is a person of extraordinary ability. What we are also seeing is with companies who have offices abroad, so they have international presence, they are hiring. So to avoid the 100,000 fee, instead of doing a H1, they're getting the folks here first on a L1 and like an intra-company transfer, and then switching them over to a H1 because they are then not subject to the 100,000 because it would be a change of status. So now coming to the H1 rules, and which is also making it tougher. First, it used to be that H1 was a bit more preferred than Ls and other visas because they used to be under a lot of scrutiny. But now what we can see is that H1 is also coming a lot of scrutiny. And I think it's understandable because the demand is more than the supply. A lot of folks are not getting through the lottery. We as attorneys, as much as this is also, we understand, cumbersome for businesses, we are also trying to tell businesses that, look, this also means that now only the proper genuine cases will go through, so hopefully there will be more numbers available, and someone you really are, who's on your payroll right now on a F1 OPT, and you want to try for them in the lottery, they probably will have more chances than before. That being said, so say you do file for someone and they do get selected in the H1 lottery. Now, a lot of rules have changed in our H1, not entirely new. Specialty occupation has been going around for a while now. We've seen 7 to 13-page RFEs on them. But now where we were still kind of, in a way, you would say, get away with it, is that we would say, for a computer programmer, you could also require mathematics, for example. USCIS is now becoming very narrow in their definition. So first, they didn't even like us saying example or related field. Now they want to know the exact fields. The good part is we do have these occupational outlook handbooks, which provide for each profession what are the most common fields. But yes, you as a company, you have to give very narrow definitions now, that if you hire somebody as a computer programmer, which are the exact fields in the sciences that you would accept. And sometimes that's very tough. Often that's actually very tough for companies, because sometimes you have someone who maybe has a whole background in accounting, but then did an MBA in the sciences, worked a couple of years, but through work experience, they got that. And it was not necessarily through their educational qualification. So that does become tricky for employers. But to have very narrow definitions of at least the job title that you're hiring the foreign national for is a good thing. So sometimes what employers do is they keep certain job titles where they have these strict narrow definitions. So if we were to hire somebody, you say, okay, can they fit into these stricter ones? Because there are some others that it's not always so easy to define them, but then you try not to hire a foreign national in those categories. So that's also some ways we have worked around it with employers, because we understand that it's not always so black and white on why you hire someone. But that being said, for these restrictive, occupations, you also need to have a role description that is consistent. So it shouldn't be that if you hire a computer programmer now, 6 months later, you file another H1 for another computer programmer, that it's so vast difference. Now, it could be that there are minor differences because of the team that they are assigned to. but the core should be fairly similar because USCIS does track that. And that's why the org chart is also very important, that if they see a slight difference, you could explain that, hey, but this is because this person is working under this team versus under that team. So there are certain skills that are varied. And why the org chart is also important is that if you have a manager who is, supervising 5 software engineers, what they like to see is that the peers of that foreign national, so you say one of them is a H1 and the other 4 are US citizens, that they all have similar educational qualifications, so that they're trying to see that there is a consistency in the hiring process of the company. That's basically what it comes down to. The key word here is consistency. So, and I will get into that also when I talk about program integrity. So, and also it could be that, example, you have in that team of 5, one US citizen who only went to high school and worked for like 18 years and now is employed on the same level like this person who you want to employ, but they don't have the formal education credentials. What we also recommend is for those folks, we sometimes you can get an academic evaluation for those folks to show that their qualification is equivalent to what the foreign national has. And the same thing, but for foreign nationals is very important. So the person you're hiring, if they, example, have a bachelor's in accounting and they did an MBA, and now you're putting them in a pure finance position for which you normally wouldn't even require accounting, then it's always good to get an academic evaluation showing that how their background still qualifies for them for that position in the same way that somebody else would normally apply for that position. um Now coming to F1s, because now most likely most companies will be relying on F1 OPTs versus getting folks from abroad because of to avoid that $100,000 price ticket. There are a lot of rules that are modernized. USCIS, I think, first was very against third-party work sites. Over the years, they have seen that that's just the way certain industries work. So now they have provided rules. So even though there are stricter rules now in place, it's in a way also a positive that USCIS has finally acknowledged the work and the style of the industries where there are third party work sites. So, and this, by having proper rules in place for how they would like for third party work sites, and we've seen the changes in the forms. Now they want the name of the client to be mentioned in the official forms and everything, which was not there before. So it does become restrictive because you can't just shift the foreign national from one third party work site to another, like how you would easily do with a domestic worker. But that being said, at least there are rules in in um, in place, so that even for the third party work site, when they are hiring, they are now aware that this is what we need to do. Because what was happening first is that a third party employer would have 2 consultants from 2 different companies, and one consultant would just be working there, but the other consultant for which who you applied a H-1B, they got an RFE, so they needed to provide more documents. And then the first question you would always get is, but for this person I didn't have to give anything, why do I have to give for this? So I feel now that they're making it consistent throughout everybody, and even for F1 OPTs to be placed at third party work sites, they can work with the DSO and ISO of their schools and get the proper documentation, and there's no difference between who you hire for them. So that's one. And then the other thing is very important is for HR. You guys have to monitor the changes, because managers will sometimes say, okay, now you're no longer working there, or you want to work remote, or you can work here. But everything has to go through HR. And then you guys have to then again get in touch with the immigration council, or in for if it's an F1 OPT, they have to inform any changes in employment to their schools. And this has become very important. Like more and more students are calling because their service gets messed up, the system where they everything is reported. when you have somebody on F1 OPT, even though it seems easy that they have a work card allowing them to work and you don't have to do any sponsorship, they have to coordinate, you have to coordinate with two folks here, with the school who has access to the SEVI system, which if anything they do to violate their system, their status, they can put that in the system, which will affect their employment at your company, and the immigration council to see these changes and everything. So you are actually coordinating with two entities, the school and immigration council, compared to with H1 where you only have to talk to the immigration attorneys, because the schools have so much access and so much compliance, and the immigration laws around F1 students is very broad. So every school can has a different way of implementing it. The government has left it open to the schools. So some schools will allow a student to do this, but another school will say, no, 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 we only allow you to do this when you complete 10 credits, for example. So every school is allowed to make their own rules within the general outline. So that's why it's very important that every change you do when a person is employed on F1 OPT, you say, please contact your school. Sometimes these students will be like, oh no, I spoke to this one friend, that friend. I know, no. I want an official email from your DSO, ISO saying that, hey, my employer is planning to do this. Am I allowed to do this? It's very good to have that compliance from HR. So always remember to coordinate with the schools. So that's one. Now coming to the program integrity of the H1. So everything has to be consistent. The LCA, the offer letter, and the petition. Sometimes you'll see the offer letter will have a different set of duties than the petitioner letter. It's very important that everything is exactly the same. The salary, you can't change. Once you have put it in one place, it has to be consistent throughout, and it has to be the actual salary you're going to be paying. The work location, same thing. What you have mentioned in the H1 on the LCA, you cannot just shift somebody from New York to New Jersey, even though it's just across the Hudson. No, there's paperwork involved. There's amendment involved. So everything, any change, even if the person suddenly decides to work fully remote, all those changes have to be mentioned, and you have to inform your immigration counsel and then see if any documentation or any changes need to be filed with USCIS. So I think another thing is that managers hiring all these employees, they have to also be trained that, look, you have a foreign national, whether it's an F1, L1, or any status, any change you do to their employment, even if you're planning to promote them, any change, please just run it by HR. HR can run it by the Immigration Council. So that's, any questions regarding no? Okay, so we can then talk about the enhanced vetting that's going on. So basically, also for the travel ban countries, these countries are subject to the travel ban because they feel there was insufficient vetting and they need to vet these countries more. They need more enhanced security. A lot of focus has now come on security. So especially we have also heard for H1 and H4, and this is something, even though they are only emphasizing H1 and H4, I would say across the board, because we also saw this earlier this year for students, social media. And I would say social media from whether you are a student on a work visa, but even if you are on a green card, until you're not a US citizen, I would say all your social media, be careful about what you're posting, what you're supporting. And I mean, there is just simply no freedom of speech, let's put it that way. And it's not only your professional accounts. So that also, a lot of people, when they're applying for jobs, like to exaggerate their resumes and their LinkedIn accounts. But sometimes they don't realize when they put that they volunteered somewhere, maybe their work visa did not allow them to do that. So I always vet all the resumes when we are doing for H1s, and often I don't even bother giving the resumes because I know people exaggerate, and if one thing doesn't correspond with their status or could be considered a violation of status, you'll have a problem. So, but that being said, that's why the LinkedIn accounts, the Twitter accounts, Facebook, if you're supporting something that's not in line with the current administration, these things have affected folks and continue. So it's not only on H1, H4. I would say this is for every single person who's not a US citizen. Should be careful about this, about their social media screening. And this is something that not only new employees or new hires should be aware of, but even your current hires who are not US citizens should be careful about this. Some notification should be going out within the company that, hey guys, be careful about your social media. Why green card holders? Even green card holders starting December 26th are going to be tracked on their travel. So if you have employees who are on green card who do a lot of frequent traveling, you should start getting a bit more mindful of that, because every travel they're doing is being very much monitored. They're getting photographed at entry and exit. So just a bit more mindful about their traveling. It shouldn't really matter, but the administration has started taking a hard call on green card holders and not treating them with the same liberties like US citizens. So green card holders have to be more careful now than they had to do in the past. Um, Also for travels, this does not apply for green card holders, but for anybody on another visa, if they need to go to the consulate to get their stamping done, a lot of delays now. H1 is already 3 to 4 months. The appointments got canceled because they want to do the social media screening. And so every travel, my advice now to everybody is travel only if absolutely necessary. Um, too many changes, too much going on back to back right now, what we are seeing, and even compared to 6 months ago. So I would say that travel only when necessary, because if it's not, being subject to the 100,000 fee, it will be to the it'll be to a 3 to 4 month delay. Some people even lose their jobs because employers can't wait that long. So travel should be very much monitored. Um, Now coming back, now I will be hitting on this in my next slide. I just checked, but the EAD cards. So this doesn't affect the student EAD cards, but it does affect the majority of EADs that you'll hire, which is people who have green cards pending, but that also means those H4 spouses who work on EAD cards. The validity period is going to be 18 months for them, which means that every time they apply, again, they are being scrutinized. Every application that goes to USCIS is being scrutinized. The budget to hire people on EAD becomes higher because you're spending on that. That being said, EAD cards, the person can pay for themselves. But a lot of companies have a policy that they will pay for the EAD cards, the work cards. But work cards, technically, the employee can pay out of pocket. So that is something that a company can look into to reduce expenses. And now the Afghan nationals are also included in the 19 country, which was different from the treaty that was first being honored. So a lot of changes, but I think overall, just keeping track of who are your foreign nationals, what rules may they be subject to, and making them more aware, because, and also for especially the F1 OPTs, whether they travel, whether anything they think is okay, always telling them, please email your school and get the okay in writing from the school. I think that's very important for employers, because anything they do wrong causes a gap in employment, which affects the work of the employer. So it's better to have them be in touch with the school. So now coming to the
Vidya, before you move on to the next one, there was a question in the chat.
Oh, sorry. Yes.
That's okay. Bill, if you want to go live with your question, you can do that also.
Yeah, sure. So I used to look after some sponsored employees in the UK, and I haven't actually done it here in the US since I've been back here. But we, when we sponsored employees through whatever visa, we had to always know exactly where they were. So they had to share their calendars with me, and even if they were going away, traveling to different sites and stuff, I had to be aware of where they were in case someone from the Home Office came in and said, where is this person? I had to say, well, actually today they're in Leeds or Bradford or wherever. Is that the same here in the US?
I think that's where the US is heading now with the ICE visits, because ICE can show up anytime at a work site. You need to know where the employee is. Are they out sick today? Are they on paid leave? Can you document that? Because I used to work also in-house
Mhm.
at Athena Health, and I actually was once there when they came on site.
Oh, yeah.
And knowing where the whereabouts of the employee is very important. And I think now more than ever, with the increased site visits, that employers need to know this. So it's okay if they come looking for XYZ and the person is out that day, as long as you can document it. It should not be that they come and even the manager doesn't know, oh, where's George? He was supposed to come in today. He's not in. Like, you can't, no, it has to be, oh no, look at the calendar. He is out today, or he called in sick and everything, because maybe they go to his house after that, God knows. But everything has to be well documented that, okay, he called in, he was sick today, or today was a paid leave, he's taken vacation, this is documented already. So yes, having everything well documented for a foreign national is very important, because we are seeing increased ICE visits, and yes, you need to know the whereabouts. And same thing now with changing work sites. You can't just randomly send them to another work site, because there could be an ICE visit at the work site.
Yeah.
And then it's like, what are you doing here?
Yeah, exactly.
Yeah.
Okay, thank you.
So it is becoming like UK. Yes. So now coming to the EAD cards, which was first a very easy way to hire someone. Now it's also becoming a bit more difficult, in the sense because they have reduced it to 18 months, but they have a lot of backlogs in renewing them, which means you can renew an EAD card 180 days before. I would suggest start the process 120 to 150 days before, because now there's no automatic renewals after since October, which means that unless you get the new EAD card, you can't continue working after the day of expiration. And now that it's only valid for 18 months, you have to do the renewal sooner than later. So, I mean, it pretty much feels like you're going to do the renewal after a year. So if it's 18 months after a year, for those who are 18 months, you'll have to file, because you can't rely on automatic extensions. So this is something very important, because also the each EAD renewal will also affect your I-9 compliance, the page 3 that you have to fill out, the work authorization, a copy of that. So it is more administration work on HR professionals, that you guys are going to be dealing with, not only keeping track of when does the work authorization expire, but also ensuring a timely renewal of it, and ensuring that I-9 documents are up to date. And that's very important also for when if there is a site visit. So hiring, so and also what we are also seeing for F1 OPT students, they are certain offices are becoming very strict. And in fact, recently somebody was traveling, and during their travel they indicated that a few days while they were away for a wedding, they worked for the employer, and then the CBP officer said, no, you can't do that, and denied that person entry into the United States. So I think it's also very important to, and this is, whereas normally OPTs could work 1-2 days abroad if they were on vacation or something, but now we are telling employees, you have to be more careful. They should not be working remotely. Of course, the whole idea behind OPT, optional practical training, is that the foreign national student gets training over here, that that helps them in their future employment. And it's very common that they go back home during holidays and things like that. But I think now for employers, and this is, we learn as we see these cases happening at the airports or at interviews, that try to avoid them even working abroad. So just trying to understand that foreign nationals, it's not as flexible for them to work anywhere or even remotely just like that. There has to be paperwork involved, and sometimes they're just restricted in what they can or cannot do. So I think that's something now that you have to bear in mind, even with folks on EAD. It's not like a green card. And I think folks were treating it as a green card, but it's still an employment authorization document that is issued to you for a certain purpose. And I think USCIS is now becoming more stricter on the purpose of that. Whereas for a green card holder, it's more liberal. So and even travel for these folks is becoming more difficult, especially when they are on that optional practical training, because if you are taking a month off, like a long period, and the employer is still able to function without you, and you are not, you're missing a portion of your training, let's look into that. So my advice to OPT holders is try not to travel. Just don't. They are already, there are talks, because you can see what's happening in the administration. There are already talks that they want to eliminate OPT program or bring it back, take out STEM and bring it back to 1 year. That tells you that the mindset is we are anti-OPT. So when you know the administration is anti something, you don't risk travel. So like example, you are from the travel ban countries, you don't take risks, or you're on a H-1 visa, you try to watch your social media a bit more. So things like that, when you are under one of those scrutinized categories, which I think as of now, every, like green card, okay, they're watching the travel a bit, but everybody till they get the green card is pretty much under scrutiny for some reason or the other. You have to be very careful. But OPT, I would say, do not travel unless it's a life and death situation, like somebody passed away, you have to go, there's no other way. But otherwise, avoid under all circumstances. They are not big fans of OPTs, no matter how much documentation you carry. We have seen some really bad incidents happen at the airports. So that's about OPTs. And now we'll touch upon the green card filing a bit. So the green card process, when you have a foreign national, is a 3-step process. You first file what we call a PERM with Department of Labor to say, hey, we're trying to, that's when you place the ads. You say, hey, we tried to find a US citizen or a permanent resident to do this job. We were unable to find one. And then we would like to file a green card for so-and-so person. Then there are 2 steps after that. One is what we call the I-140 petition, which is pretty straightforward, that you as a company have to show that you have the finances to pay the salary that you're offering, and the employee has to have the credentials for the job, and the 485, which is the actual green card application where you get the EAD and everything. But now the PERM, the process that goes through Department of Labor, they had an outage in October, November of this year. Now they were very accommodating, and they gave some filing deadlines. They extended them and everything. But just like how COVID caused a backlog in cases, this outage, already they were running behind, has added several months to filing even a simple thing like a prevailing wage, like what would be the wage required for the job for you to even start the ad process. So it's already, that itself is taking up to a year. So what I know, a lot of companies, because I've even worked in-house, normally you have a policy that, hey, when we hire somebody, we wait a year before we start filing the green card, which is normal because you want to see how that person fits within the company, because on paper and during the interview it's different, but when they actually start working for the company, that's when you really get to know the person. So I totally get that. But I think now, if you really want to retain this person, green card processes should start much earlier, maybe 6 months or 3 months. So have a quicker onboarding process, because it's still going to be a long process. And also, what I would say is, I'll just get to that question later. What I would say is, you're not making a lot of expenses in one go. You can talk to your immigration counsel. Filing a prevailing wage doesn't cost much, and that whole, just finding out what is the wage for that position. Yes, you have to already finalize your job description for the green card and all, but there's no filing fee for that or anything. So as an employer, expense wise, you can start at a lower expense. But yes, you are a bit, and you're not really committing to a process. So say you file the prevailing wage, but in 6 months you let the person go. You have not filed much or done much paperwork with the government at that point, because the prevailing wage doesn't even have that person's name, if I remember correctly. So you can withdraw it after it's certified. It's a very simple process, not like you've applied for the full work visa or anything like that. So I would say commitment wise, budget wise, it's not too high. So I would encourage employers to consider, because a lot of times employers wait and then rules change and then it gets delayed, and then sometimes very critical employees you want to retain cannot stay in the company because their work visa is up, and only if certain steps of the green card were done, then only the H1 can be extended. And if you don't have an international presence that you can transfer them temporarily for a year or two to another office, it becomes very difficult. But sometimes even employees, it becomes very difficult because they would have bought a house by now, their kids going to school. It's disruption on both ends. So I would say with all these delays, I would encourage companies to at least look into starting the prevailing wage. You're not even paying for ads yet, just starting the prevailing wage process and finalizing the job description for the green card, so that moving ahead it becomes easier, and it's a more timely process for the employees, because there are certain rules, like the H1 can only get extended if the green card was filed by a certain time, or the I-140 is approved before the 6 years. So things like that. And let me see Bill's question. Yeah, well, I mean, you don't have to know after work where they are going, but I would say during their work day, you need to know their whereabouts, because ICE visits are increasing. So and when I say whereabouts, it doesn't mean that when they have reported to work, because a lot of buildings, they have the scan system, they've come into work. Now, they could have gone for lunch or something, not that time. But if on a particular day they're attending a conference in another town, that should be documented. They have not reported into work that day because they were sick. That should be documented. And I think just generally that is because, as an employer who is hiring a foreign national, you are also having a commitment to the government. So it's not like very precise whereabouts, but knowing where is the employee on a work day, whether they're at work, called in sick, on vacation, at a conference, visiting a client, that I think it's fair to assume a manager should know that where the employee is. I hope that makes sense. Any questions? No. So to the next slide, we can go. So it's very important to know your foreign nationals, but at least identify the ones from the 19 countries, because you will then know that any further case processing from those countries, what issues will come up for those employees. Engaging with immigration counsel, and I mean, it's not like tabs on employees, but if you're changing their work sites or changing anything within their employment, from even from full-time to part-time, any changes, maternity leave, things like that should be reported to immigration counsel, and well documented. Everything can be done, but it has to be documented, so that if tomorrow there is a checking, or there is an RFE, a request for evidence during a case file, my advice to employees is, yes, you can take a maternity leave if you're on H-1B. It's normal. Women do that. But everything has to be documented. As long as you can document it, that's what they care about, So, so that. No, I was actually talking, I was to the question of Jennifer, I was only referring to foreign nationals. So what USCIS expects is, there's no what they expect is that when they come to the work site, they expect to see the foreign national who you sponsored, who you said will be working there, what an employer attested to. Now, if the foreign national is not there, then it is reasonably to expect for the officer that you would know where they are, like if they didn't come in, they're on vacation, things like that. That's what I was trying to say. I'm sorry if there was any confusion about that. So that and also you need to also know about when a green card holder is traveling, especially now that you know that they are tracking their travels with the photographs on entry and exit. This is not something that was there before, but now these changing rules are having employers having more, I don't know, screening or something more, more insight in what your foreign nationals are doing, like whether they're traveling and all. Because if they're traveling and you know in their home country there is a massive delay in stamping, so then the first question is, do you need stamping? You know, as an employer, you need to be aware of that, because if they do need, and tomorrow there is a delay, you might not have the employee back in the country for another 3 months. So all of this does have an effect. Or if somebody on a green card, they filed for the I-90, which is a renewal of the green card, that's still pending. Normally that, you know, they can travel with just a receipt notice, but just to be careful in those circumstances as well. So things like that, I think employers, yes, they have to be more aware than they used to before, just because the rules are changing. Budgets, like I said, H1 employer has to pay, but EAD employees can pay. So how you want to balance that out as an employer in your budget, that's something to look into. Communication, I think a lot of times also, that having, once you've identified at least the ones from the travel ban countries and all, what we did is, I remember when I was working in-house at that time, it was a previous Trump administration with the travel ban, having meetings with these employees and and understanding where they are at and what their concerns are. You know, a lot of them are already following the news. They probably also will not be planning any travel anytime soon or anything like that, or they must be already aware of their social media screening and things like that. But just, you know, identifying those employees, connecting with those employees, and them knowing that they can rely on their employer for support. Because the lot of calls I get from employees that don't feel that they're getting sufficient support from their employers' attorneys. They're like, oh, they only support the employer, even though it should be, it's a joint package, it's employer and attorney, a H1 petition. So a lot of times they call and they're afraid. And I think if you know, the HR or the managers, or you know, someone like a, or there's a point person, a lot of companies, that's how I also, they have an immigration in-house specialist, have someone that they can turn to, so they feel that they're supported. And also a lot of times, not all of them contact an attorney. They will just hear what their friend did, or what someone, or read online blogs and make a decision, and suddenly travel, and suddenly the employer will say, oh, but did you not, weren't you aware of this? They're like, no, we read, it was fine, and they did it, and then they're stuck somewhere. So making sure that they're well informed is very important, and that only happens if you're connected, you know. And train management, you know, anti-discrimination, I know it will now become tougher having employees from these travel ban companies and countries. But that being said, you can't discriminate among where someone is from. So yes, this all is going to become very tricky, and having certain policies in place on how you're going to navigate through them is going to become very important. I-9 compliance, because of all these work authorizations expiring sooner, and having some protocol in place for site visits, which are increasing right now. And monitor changes. You know, any alerts, USCIS has alert systems. We immigration attorneys, we get it through a different alert system, but you know, just or having maybe you know, a connect with the immigration council on a regular basis. But yes, daily changes, having these alerts, because you want to feel as an employer you're aware of something when the employee approaches you. Any other questions?
I have a question. So on the discrimination piece, how, if you have somebody that's on OPT and you're going to move them to H-1B, but you can't afford the 100,000, right? In your budget, you're a small business and you just can't afford it. So you tell them you can't do it, but then you have somebody who may have had H-1B or they're renewing or whatever, or they're on the L, and you're able to transfer them so they don't have the $100,000 fee. So you move forward with their application. How
But
is that?
F1 to H1 also, there's no 100,000 fee. It's only a person outside the country.
Okay, so if they're on OPT to H-1B, that wouldn't be
No
100,000?
fee, no fee.
Okay, great.
Yes, no fees. So once they're in the country on a different status and it's a change of status, there's no fee. This is only if you have a company here. Example, I have a law firm. There's this amazing lawyer in London. I want to hire him or her on a H-1B. They are subject to the 100,000, like I have to pay 100,000 fee for them. But if they
New
came
coming
here,
in.
yeah, if they came
Okay.
here and they are studying, at Harvard, and I'm just doing a change of status from F1 to H1, there's no 100,000 fee.
Okay. And Brad, I had the similar question on Canadians too.
So Canadians
Oh,
have
okay.
the advantage of the TN visa, but the TN visa doesn't lead to green card. So a lot of times what employers do is TN is fairly simple. You provide a letter, they go at the border, they get a TN stamp, or they can even go to the US consulate. So yes, Canadians have that advantage. And then what you do is you keep putting them in the lottery here till you can change their status. And because it would be a change of status, they would not be subject to the 100,000 fee.
Gotcha.
But for
Got you.
TN, there's
Thank
a
you for
limited
that.
amount of professions you can do it for. But most professions, like I've even done it for journalists, like most professions, you can fall under TN, the most common ones.
I see. Is that so there's no change in that specifically? Like the ease of getting that visa for Canadians into the US that's not changed?
Lately, I mean, it's been a while since I've done a TN, but
Mm-hmm.
I've not heard anything about a TN. But of course, if a TN comes my way, the first thing I'll ask everyone is anything. But so far, I've not heard anything crazy happening with the TN. That being said,
Mm-hmm.
anything can happen. But yeah, so far, that's been okay.
Right. And you mentioned that that particular visa it doesn't have a pathway into a green card. Is that correct?
No.
So where does it stop? I'm based in Toronto for what it's worth in
Okay,
terms of
so
why I'm
basically there are
asking.
certain visa categories like TN, E2 investor visas.
Mhm.
From that status, you
Mhm.
can't file what that last piece I was referring to, the 485, the adjustment of status to a green card, which
Right.
means that to get to that, you have to switch a status. So what a person on TN usually does is the employer, if say the TN, the Canadian national says, look, I want to really stay here, the
Mhm.
employer will just keep trying for them in the H1 lottery, get them on a H1, and then start the green card process for them.
I
And
see. That's the process.
yeah, so
Gotcha.
that's usually the most common process that employers do for folks on TN.
Got you. And now with the H-1B visa, is there a difference between H-1 and H-1B? Or they're the same thing?
You know, it's the same on H1.
It's the same one. So, and I'm guessing with the $100,000 fee attached to it, that includes even if it's Canadian, right? If you're on a
If
TN,
so
yeah,
not TN, because TN means you're in the country. That is
right,
change of
right.
status. But if you're a Canadian and
Hmm.
you're in Canada and I file a H1 for you in this year's lottery and you have to go to the US consulate there, then you are subject to the $100,000 fee.
Copy that. But if you are in the US, if a Canadian has gone from Canada and now is in the US on a TN visa, and now they're transitioning their status from a TN to an H-1B, does
Then
the
you
hundred
should,
thousand
no,
then the
no,
hundred
change of
thousand dollar
status, it does not apply to.
it doesn't apply. Okay, got you. And the O1 visa, are Canadians eligible for that, or is that a general visa?
That's a general. It's like H1, but
Okay,
O1 is more for person of extraordinary ability. But now we are seeing an increase of folks applying through that,
got
um,
you.
because then the foreign national won't be subject to it. And
Mhm.
also, the other thing is that you're not subject to the lottery also. And if you anyway have to pay a higher salary through the lottery for that person to get through because they're looking into starting that preferential system, then you
Right.
might as well hire, if the person has the qualification, hire them on an O1.
I see what you're saying. Copy that. Copy that. Thank you. This was very informative.
Okay, you're welcome. Well, I don't know if Harish is still there, if he wants to add something, but if there are no other questions,
Thank you, Vidya. I'm leaving this last slide on with contact information for Vidya and myself. Just a little bit about Crossing. So we're building this AI-powered immigration case management tool, which helps companies keep up on top of all these deadlines, breaking changes that come in, etc., and also build out a very simple immigration case management tool that allows people to track every single change that's going on within the cases that they're filing for the employees, etc. So happy to give anybody any information on that. And obviously, Vidya is available via her email if somebody has additional information they want and want to
yes.
speak to a lawyer.
So I've been giving Harish feedback from attorney's perspective and HR perspective because I've also worked in-house and I've worked with HR professionals. What would be required? And I think one of the new tools I told him yesterday, I said you should add is that whenever you log in, the system, there should be a pop-up with today's new immigration news. I think these are things that not only attorneys but for HR, because there's just so much to keep up with. There's just so much, like while I'm speaking now, before you know, there could be another announcement made, or like when I prepared the slide, the 20 countries were added literally the day after, like yesterday, and I was like, oh my God, we were expecting it, but so I think it would be nice to get feedback or what you guys feel that you would like to see in a system, because I feel this system has already got a lot of feedback from attorneys, and I think one thing I like about it is that we have a lot of stuff to do. Even HR, you guys have more beyond the foreign nationals to manage in a company, and it's so much. But for every foreign national, their case is the most important for them, and they expect everybody to treat it with the same importance. So I think them having the direct access to a system where they can see the progress is the main, and I think that takes a lot of burden off from HR professionals and attorneys, because it's a very sensitive issue. Immigration, it affects their whole family, their spouse, where they work, their kids going to school. It's a lot. So I think them having some type of access, but not the full direct access to the Immigration Council, which a lot of companies like to segregate, would be nice, so that they feel that they're somewhat in control of their case, but not completely, but that they're getting updated, and I think that's a very rare tool, and I like that a lot. So if anyone is interested to do a demo, that would be great.
Yeah, I saw the tool. I was fortunate enough to get a demo, and I've done a lot of H-1B visas and green cards. And one of the biggest things, and Harish and I spoke about this, is that it causes so much angst for the person going through it, because it is a bit of a black hole, right? You submit these documents and you kind of sit there and cross your fingers and hope that you get a response at some point that's positive. And with that system, it gives so much visibility into the process and where your application is at. And you can give the employee information instead of saying, oh, I don't know. It's the worst thing you can do with somebody going through this, because it affects their whole livelihood, right? It affects their family, it affects their job, it affects their whole livelihood and whether or not they're going to be able to stay here in the US. And so it creates a lot of angst for them. And so this system gives you and the employees so much visibility. It really is a really great system. So definitely check it out. And I love what you're doing with it. So it's definitely going to help. It's going to help the HR person too. So much time it's going to be saved.
Trust me, I've sat through those meetings with HR and they're like, oh my God, this is just so much. And I'm like, I feel bad because there's so much you guys have, like, it's,
painful.
It's very painful, but so I get it. And that's why I gave him all that feedback, having worked also in-house very closely with HR professionals, seeing how the employees feel in the company, getting the phone calls, that how the ones who don't feel supported, and especially the ones in smaller companies where there is no proper HR person or things like that, they don't even have that support. So giving him that feedback. But yesterday I was literally telling him when I prepared the slides and I saw that I was like, you need to have a pop-up system that when you log in, that this is what happened,
Yeah,
because things are
especially
changing
now,
so
more than ever.
quickly. Yes,
Yep, exactly.
So,
Wonderful.
yeah.
Well, this program, I put it in the chat too, but this program has been approved for 1 HRCI recertification credit. The code is 726018. So anybody watching this on record, use that code for your recertification credit. Thank you so much, Harish and Vidya. This was fantastic. We will have the recording sent out in our newsletter with contact information as well. So if you want to schedule that demo or get more information, that's how you can reach out. And then in January, to continue the conversation on immigration or global, where we're going to have Dominique talk about maintaining an intentional culture across global teams. And we're going to try to get global HR recertification credits, which are super hard to get for those of us that are globally certified. So make sure you tune in for that in the new year. Happy holidays, everyone. Happy New Year. We will see you in the new year.
Thank you. Bye-bye.
Thank you, everyone.
Awesome.
Thank you, Michelle. Thanks, everybody.
Bye.
Thanks. Cheers.